Well, thank you, Chief Justice Rabner. Thank you to Judge Grant and to all of our friends at AOC for organizing this judicial conference and for assembling such a diverse and distinguished group of New Jerseyans to tackle this important issue. I think everyone in this room knows this, but it bears repeating, which is over the last 10 years or so, the leaders of the New Jersey Bar have tackled some really significant challenges, as the judge spoke about. And we have worked together to strengthen our criminal justice system. I think the most noteworthy of those reforms involve the elimination of cash bail. And the point that I want to make at the beginning of my remarks is what was so noteworthy about so many of these reforms was that they were done by consensus, with folks from across the ideological spectrum coming together to agree on a solution. And that included prosecutors and public defenders and folks who don't often agree in the courtroom agreeing on outcomes. Not everyone got everything that they wanted, but everyone got the chance to be heard, and we were all the better for it. And I hope that those past efforts can serve as a model for what we are trying to do here today. To borrow the judge's metaphor, we shouldn't just renovate the house, but we should renovate it together. And to that end, I want to say that I come here with an open mind, ready to listen and hear what others have to say and follow the evidence wherever it leads. And so as the first speaker, I thought it would be useful not to lay out red lines in negotiation, but instead to try to help frame the conversation for what we'll be discussing over the next day and in the coming weeks and months. So as we talked about on Wednesday, courts have long held that juries must constitute a quote unquote representative cross-section of the community. And it's my personal view that that is not simply a constitutional obligation, it's also a moral one. And our system of justice cannot function unless it reflects the rich diversity of our state. I think we all know that broad representation doesn't just lead to better and more fair outcomes, it also bolsters public confidence in those outcomes. And I worry that there are too many New Jerseyans, especially in Black and brown communities, who feel like they don't get a fair shake in our criminal justice system. And we risk further marginalizing these communities if we cannot ensure basic fairness in our jury selection process. And it's part of the reason why I'm so glad that the Chief and Judge Grant have assembled this conference. So how do we achieve a representative cross-section? I think it is helpful conceptually to split this into two parts: the composition of the jury pool and the voir dire process. Why? Because essentially what we're trying to get is a jury pool that reflects the rich diversity of our state, and then ensuring that we preserve that diversity as the jury selection process moves inside the courtroom. So first, the composition of the jury pool. I think we have to start off by acknowledging that jury service is a responsibility of citizenship, but it is also a burden. And the weight of that burden too often correlates with the precariousness of one's personal finances. It is much easier to serve on a jury if your daily salary is not the sole source of your family's income, if you are not the primary caregiver for a young child or an ailing parent, if you're not dependent on public transportation to get between towns. And we must find ways to ensure that we don't exclude these folks from jury service, not simply because their lived experiences provide an essential perspective inside the jury room, but because we know that too often in New Jersey, wealth and job stability are proxies for race. And related to that, I hope that one of the things that we can tackle here is the really difficult task of determining what exactly constitutes a financial burden so substantial that it warrants excusal from jury service. Because without a clear standard, judges are left to solve that on their own. And that can lead to a fair amount of lack of uniformity in how those decisions are made. I also hope that we can explore whether to modify any of the restrictions on jury service that Judge Grant spoke about. As we all know, that in New Jersey, we categorically exclude jurors from service if they've ever been convicted of an indictable offense. And obviously, in recent years in New Jersey, we've moved away from that in a variety of other areas, including in employment and in housing. And so one possibility that I would proffer to this conference is that we depart from a categorical exclusion and instead conduct an individualized analysis of potential jurors with a criminal history that takes into account the recency of prior convictions and the relationship between the person's criminal record and the matters that are going to be considered at trial. The second thing that I want to discuss is voir dire. And I know that this conference is going to focus in the coming months on peremptory challenges. That's where a lot of the action is going to be. But I actually think it's important to start with for-cause challenges because they offer certain advantages that we should discuss and flesh out. Because for-cause challenges are structured like so many other processes in our adversarial legal system. One party proffers evidence about why a juror should be removed. The other party has the opportunity to refute that evidence, and then a judge makes a decision based on the facts and the law. That structure promotes transparency and accountability, with the judge serving as a check against improper gamesmanship. Peremptory challenges operate differently because they are, well, peremptory. And they, without a doubt, often offer certain benefits, including speed and efficiency, and they allow veteran trial attorneys to rely on their gut instincts, which they have honed over many years and which oftentimes are difficult to articulate during the for-cause removal process. But the same attributes that make peremptory challenges so appealing to lawyers are also what make them prone to abuse, for the reasons that Thurgood Marshall articulated in his Batson concurrence. And frankly, as we have seen in so many other contexts, when we create a system where individuals are not required to justify their actions, sometimes individuals in that system will act in ways that are simply unjustifiable. So the question is, what do we do about it? I think as a starting point, we work to strengthen the process surrounding the for-cause challenge. I think we need to make it easier for trial attorneys to learn meaningful information about potential jurors. And we should do this in part so that attorneys can actually articulate what their concerns are with jurors, as opposed to having to just rely on their gut feelings. And I think that we can work together to develop guidance about what constitutes a permissible basis for removal and what doesn't, so that all the parties understand the rules of the road. And it's my view, at least, that if we implement such reforms, if we create a more robust for-cause removal process, we may find that the need for a significant number of peremptory challenges quickly dissipates. I will be the first to admit that I don't have all of the answers. And I genuinely look forward to hearing from others today and in the coming weeks and months. But I really, truly, genuinely believe that if we work together on this, if we all listen to each other, to our concerns, and to the evidence before us, we can come up with a solution that reflects the best of what this community has done in the past, and we can create a justice system that is fairer and more just for everyone. Thank you.
Thank you, Jim.